Why not combine it into a career? Well, indeed.
That's yeah. I'm just thinking how it applies to considerations of directives. Legislation coming down the track. My understanding is that not sure when they'll publish draft bills.
Welcome back, everybody. Last few people coming in. And we're there. Welcome back. Do you remember I told you about the challenge board? That board out there where you go up and you write things on it and put things on there. It's looking very, very sorry for itself still. I think lots of people did not challenge themselves. They walked straight past the board. It's actually a really important part of today. So when we finish today, can you form an orderly 4-mile long queue and write something on the board that you actually think we should do? Because again, it is important. We really want to see that challenge board with lots and lots of things on there so we can take those away as takeaways from today. Tanya, how is Slido looking? Is it looking any more full than what the challenge board is looking?
Not currently, but would definitely encourage people to start participating over the course of the next couple of hours. But I'm happy to share some of the feedback that was relayed prior to lunch in relation to ethics off the back of some of the sessions we had with Dan Needle and then with Richard Orpin. So one of the questions that was asked was around, well, quite a few questions actually around culture and the role of regulation. So an example of that is ethics. Someone said there's prevention, promotion and protection, the 3 Ps of regulating in the public interest. And they said it seems that the LSB's consultation is trying to achieve this, but what can the profession do to encourage ethical behaviour outside of regulation to change a culture, and where can there be a bit more collaboration? We also had some other questions, some practicalities. So should regulators have phone or text points of help and advice manned by practicing individuals? For instance, responses to difficult ethical questions. I think there are some provisions in place by some of the regulators in relation to that, but definitely open to wider discussion. There's also a question around regulators paying a lot of attention to misuse and financial irregularities and complaints in that nature. But the question sort of asked, rather than ethical sort of lack of integrity, there seems to be no comeback for misleading the court with factual lies to avoid things like an injunction in relation to ownership of land, as an example. So just a few questions out there to get the ball rolling for you panellists.
So some very valid comments, valid questions. Please do keep them coming, both on Slido, and as I say, when you go out to write things on the challenge wall, I'll never let you forget it if you don't do it, and I know all your email addresses to send you a slap. So the topic for this afternoon is beyond policy and theory, and the question we're asking is, how can regulators and leaders keep ethics at the heart of legal practice? A really important question. actually that we need to tackle. Professor Stephen Mason was originally called to the bar by Lincoln's Inn, of which he is now a bencher and chair of its regulatory panel after spending a period as a tax lawyer, another tax lawyer in the room, with another Magic Circle law firm as well. He developed an international reputation as a strategic advisor in the legal sector, working in a range of strategic, financial, ownership and governance issues with law firms and corporate and government legal departments. More recently, he has held a number of non-executive directorships and retained strategic advisory relationships with law firms and law-related businesses, and is currently non-executive chairman of an ABS law firm. I'm delighted to welcome Professor Mason to the stage to chair our next panel.
Thank you, Dean. Thank you. And those of you who know me will know I also have a bit of an interest in legal services regulation. So we're going to use this morning's consultation paper from the LSB as the platform, the jumping off point for our panel discussion. Again, I want to emphasise this session isn't about identifying what the problems and challenges are. They are very eloquently put out by the consultation paper, sometimes in excruciating and embarrassing detail if you are a qualified lawyer reading what some other qualified lawyers are doing in the name of their profession. But we're not going to concentrate on that. We're going to say what happens next. Where should we be going with regulation, with regulatory intervention, and with the broader environment within which that regulation takes place. I'm not going to introduce each panellist, if you don't mind. We're going to try and use the time for content. Hopefully you'll be able to match photographs and descriptions with the people you see in the chairs, and that will save me the bother. So let's start with, I haven't got time to go through all of the suggested outcomes in the paper, but I'm going to start with what is proposed as outcome 1, which is about the knowledge and skills required at qualification and beyond to establish and then sustain ethical behaviour. So if I may, I'm going to start with you, Sophie. Yep. An accountant's view. So that's the other thing. This is not a panel of lawyers. We do have a couple of lawyers, but accounting, directors, and pharmacy as well as law. So again, hopefully we'll get a perspective on how this might be done in spheres beyond law that we can then adopt and adapt.
Thank you. Hello, everybody. So, as Stephen says, I'm not a lawyer. I'm a chartered accountant. I'm also a chartered tax advisor. And I'm here from the Institute of Chartered Accountants in England and Wales. And we're here because we're a legal services regulator for probate. So I thought it was worth sharing that we've introduced a new continuing professional development regime recently. And as part of that, we've introduced mandatory ethics CPD for every single member every single year. So there must be a minimum of 1 hour of ethics completed every year. But why have we done this? It comes back to trust in the profession. And the accountancy profession has had some challenges. There have been some really high-profile corporate and auditing failures, and questions have been asked about trust in accountants. And to me, trust is about, is somebody going to be competent in what they do, and are they going to do the right thing? And that do the right thing is where we come back to ethics education. So to support members with this, we have produced an ethics CPD course that really takes them back to the fundamentals of what does it mean to be a professional? Why does it matter that you're ethical? And it's reminding people that you are put in a position of trust as a professional, and it's really important that you act in accordance with that trust. And I think that's a really important fundamental in our ethics education programme. And we worked with the Institute of Business Ethics to develop that. Our course then reminds people what our Code of Ethics says and what the fundamental ethical principles are. Now, all accountants learn about that when they train. Is it something they think about on a regular basis? Perhaps. But I think it's helpful to remind people that those are the underlying principles under which they should conduct their activities. But that's not enough, I don't think. So it's a reminder of that, but then also there's content around, so what do you do if you're then faced with an ethical problem? How do you navigate that? Because being able to quote the Code of Ethics is great, but is it going to help you when you're in a bit of a dilemma? and you don't know where to turn. So there's some tools there, some suggestions and guidance on how people can approach that. The course then also has some specific modules in there for specialists, because anyone who's dealt with an accountant knows we do all kinds of things. So what are the ethics you should be thinking about if you're an auditor? What are the ethics you should be thinking about if you practice in tax, for example? And there's some really important things that people need to bear in mind when they're working in those areas. In terms of the take-up with this, we introduced this in November 2023, so we've had one CPD year where this has been in force. And although we're not mandating the course we've produced, 50,000 of our members have done at least 1 hour of that course, and that's out of 170,000 individuals. But we also know that a lot of our big firms have taken that course and put it on their learning management systems and have made all their staff do it. So we think actually a very high proportion of our membership has done at least 1 hour of that ethics course. And going forward, every year we're going to produce some new modules for that, so that people have got some new content to look at. And this year there's going to be a module on AI and ethics, which is obviously a very topical issue, and then more broadly on developing an ethical culture. So we think that early indications suggest that this mandatory ethics CPD has been a success and that people are engaged with it. And I think maybe it's something that the legal sector could consider.
Great, thank you. As I look at it, there's a difference between what a regulator might require and what a professional body might want its members to do and to be. Any read across from the pharmacy world?
Well, I was going to talk about the onion, which is in terms of the layers, in terms of, you know, we've got the regulation, we've got the advice from the professional body, and then also, you know, how things actually work in practice, because it's all very well having guidance and reams of paper and things to read, but actually, how does that work on an individualised basis when you're dealing with real patients or real clients who don't always necessarily have the same expectations as, you know, your professional body or regulator requires. I think in terms of the pharmaceutical profession, so on day one of qualification, in terms, let me just go back a tiny bit here. So I did a 4 years master's, and then 1 year's in practice, and then an exam to qualify as a pharmacist. And then I did a GDL, an LPC, and then 2 years in a law firm, Hempson's, where we didn't have any sort of exam at the end of that. And that was 2 very different experiences. But on day one of being a regulated pharmacist, I was essentially in charge of every operation that went on in that pharmacy, and still am as a responsible pharmacist, compared to on day one in a law firm where I'm reliant on other people to supervise me, and perhaps need to even vehemently say, absolutely, no, I can't do this because I haven't got the skills to do that. I think that those are 2 very different experiences for people who are probably, I'm going to say, about the same age range, but it shouldn't be down to age. We know that lawyers are qualifying a little bit later, around 29, for example. But that's 2 very different professions and experiences, highly regulated, but very different experiences. And I'm not sure it's completely fair, I would say, for a newly qualified solicitor to potentially have to push back occasionally. So actually, I'm not qualified to do that. I'm probably going a little bit outside the question here. One last thing. Pharmacists are going to be coming out qualifying as prescribers, so they will be able to, you know, diagnose you and then provide medication, essentially. We're doing that a little bit now, but it's changing. And the people who supervise them to do that are now going through competency frameworks to be able to provide that. I don't really know where that's happening in the legal profession. We don't regulate managers. We don't give them any sort of mandatory training so that they are supported to actually do what they do, because you don't want to be in a situation where actually people leave the profession because they experience behaviours which they don't want to experience. And we know we've got, I was actually laughing this morning because we've got this Gen Z culture. We're saying, you know, Gen Z, they like to, you know, say things as they are, they aren't scared. But actually, I'm looking at that thinking, is it because the millennials have been too scared and been trying to walk this tightrope? And we're now seeing a generation who actually probably are practicing portfolio careers, because we're seeing that more. I mean, I'm doing about 20, so. But more portfolios careers means actually people will choose what they want to engage with, and if they don't have somewhere supportive and an ethical framework which supports, and we know they care more about sustainability, for example, why would they choose to engage with that?
So there's a training element to the development of knowledge, and there's a broader professional and organisational support structure that you need to develop the skills to be ethical in the real world. I guess I might be slightly concerned that there is a hierarchy in practice, particularly in your junior years, and some of that, the effects of that hierarchy and the pressures that it brings, could well stamp out some of the professional independence that you're supposed to have as a lawyer. And you become dependent on somebody else's decision about, yes, you do this, or no, you don't. And you probably don't have the experience to push back on those things where somebody's saying, yes, you can do that. And instinctively or ethically, you're saying, no, we shouldn't. So there's a set of tensions in all of this. So we definitely need better training to be designed and delivered, but we need a lot more to sit outside it. Okay, we need to move on, because we could spend 3 hours on each of these outcomes. Let's move to outcome 2, which is a framework of rules, regulations, guidance, and other resources. And Roger, I'm going to fire 2 questions at you. One of the things we heard this morning was that there is evidence of a lot of pressure being brought to bear on lawyers to do things that the business wants, but might not be ethical, and the pressure on either the internal or the external lawyer to do those unethical things can be intense. If you've got a perspective on that you're willing to share, I'd love to hear it. But more importantly, I know you've recently introduced some IOD guidelines for the way in which these things probably ought to play out. And again, I'd be interested to hear how you think those guidelines should be best used on both sides of this particular equation, the corporate and the legal service.
Yes, well thank you, Stephen. Something that the IOD did last year was a study on the post office scandal, because this was just such a horrendous miscarriage of justice, and we wanted to learn the lessons, quite frankly, in terms of what had gone on. And the public inquiry which took place, which had just concluded in December, was a kind of unique opportunity to, look under the bonnet of the boardroom, email by email, scratch note by scratch note, to find out how people were responding to the situation. And I definitely think that the relationship which emerged between lawyers and board members was pretty dysfunctional in that case, which if that is a common type of relationship, then it is pretty worrying, because it almost seemed as if lawyers and directors were locked into some kind of dysfunctional loop, which was taking them towards taking bad decisions. So legal advisors, both internal and external, seem to have internalised the rather toxic culture which existed at the post office, particularly in terms of their attitudes, or management and board attitudes towards the sub-postmasters, thinking that these are people that are not to be trusted, they're on the take, they've got their hands in the till, we need to really deal with them in a very heavy-handed, punitive manner. And then you have the board, whose attitude was, well, we are being told to do certain things by the lawyers. We just have to do what they say, because that's the law. And we can't argue back against them. They are the repository of legal knowledge, which we must follow. So you had these 2 groups who were then sort of locked into a loop, which led to very awful decision-making. And really the only way out of that situation, I think, for both parties, was if they had been able to exercise a better degree of independence in their thinking, and if they had been able to apply a stronger moral compass, both in the advice that they were giving and how boards were acting on that. And that just didn't seem to be possible. So this very much emphasised to us that we need to take a look at the ethical dimension of directors' decision-making as the Institute of Directors. And that is actually at a very immature stage, because there is no real regulatory framework for being a director. I mean, there are baseline legal duties, that there is, there's certain regulation in various areas which applies to directors, but there isn't this overarching regulatory framework. Pretty much anyone can become a director. You just have to be over the age of 16. You mustn't be an undischarged bankrupt. You mustn't be disqualified as a director. Then you can become a director, and you can. And there's no code of conduct or moral guidelines which might affect your practice. There are no educational prerequisites either. So we felt that we needed to take some steps towards creating this framework. And last year, working with a commission under the chairmanship of Lord Ian McNichol, who's a peer, a Labour peer, we developed a code of conduct for directors. So this is a voluntary code. It doesn't have any legal standing, actually. But what we're trying to do with this is just to shift the culture in terms of what reasonable, responsible director behaviour looks like in a variety of real-world situations. We were very conscious of the fact that directors are very cautious about new regulation. If we had suggested to them, well, we need some new mandatory regulatory framework to govern directors' behaviour, that would have gone down like a lead balloon. It absolutely, that they are already feeling that their discretion, their ability to act and exercise their judgment is very heavily restricted anyway. But we wanted nonetheless to try and shift behaviour in a better direction. So we developed this guidance. We simply hope that directors will use it as a tool, as a resource. And just even if it helps that situation where the new director walks into the boardroom, they see how people are behaving. They feel as if something's not quite right, but I'm the newbie, so I can't really challenge this. Well, actually, here is a benchmark, a framework, which can be used to reflect on that behaviour and can potentially be used to challenge it. And it can also be used by stakeholders as well as they look at what directors are doing. So it's not a mandatory framework of regulation with enforcement and investigations and people being struck off and all of those more normal aspects of a regulatory framework or sanctions. But it's a start, we feel, and we want to really use this to nudge the culture in the right direction.
And let's be fair, that nudge can have positive outcomes as well as negative ones. In other words, the directors can use their position of influence to encourage lawyers to behave in a different and hopefully more ethical way. It's not just negative pressure that they're bringing to bear to get the lawyers to do some obnoxious things.
No, absolutely. I think to some extent I see it as being a way of giving directors self-confidence to understand what they're there to do, to understand the sort of things they can ask for, they can demand, they can challenge on, so they ultimately can better fulfil their role as directors, because especially during the post office scandal and in many other scandals, it's actually remarkable how directors very easily slip away from doing the job that they're there to do, which is to be an independent sort of conscience of the organisation that is challenging behaviour and challenging decision-making, and is trying to keep the organisation, aligned with its purpose. They can be very easily derailed by that. Groupthink can set in very easily. A toxic sort of amoral culture can set into business decision-making very easily. So I think it is important to have this benchmark that at least can be used to reflect on, is this responsible business behaviour? Is this really the right thing that we're doing? Does it pass the smell test?
Yeah, absolutely. So there's obviously a spectrum: law, regulation, code of conduct, guidelines. You've got guidelines in giving tax advice, but coming out of a professional regulatory background. So is your approach to promulgating and enforcing those guidelines different?
Well, I think it's probably useful if I give some background on the guidance we're talking about here. So the professional conduct in relation to taxation is something some of you may have heard of. And I talked about challenges the accountancy profession has had. We've had quite a few. If you cast your minds back nearly a decade, it was daily headlines, wasn't it? Tax avoidance. political criticism from society. And we as a profession came together with the other accountancy and tax bodies and said, we've got to do something about this because it's not a tenable position for the profession. So we developed some standards for tax planning within our professional conduct guidance for tax. And one of those standards said that our members must not create, encourage or promote tax planning that is highly contrived or highly artificial or goes against the clear intention of Parliament when setting that legislation. And that was quite a fundamental change for the accountancy and tax profession. And we developed it in a way that it was enforceable. And we made it very clear to our members, this is where the bar is. This isn't about what's legal. This is about what's ethical and what's acceptable but conduct for you as a professional. And if you breach it, we will discipline you. You can imagine how well that went down. It was a real shift in, I think, the attitude that had been present before that, which was, well, tax avoidance is legal. So if it's not illegal, I can do it. And it's up to HMRC to prove that it doesn't work. So there was a journey for the profession in developing that, embedding it within the profession. But actually, I think where we've got to is it's a really good example of where societal change has led to regulatory change, which has led to cultural change in the profession. If you spoke to an accountant today about some of the tax avoidance schemes that were done 10 or 20 years ago, they would nearly all universally condemn those schemes and they would not do them anymore. And that has been a real shift that has been triggered by concerns about trust in the profession and the ethics of professionals. But from the enforcement point, clearly there's a time lag, but we have now taken disciplinary cases against our members who we say breach those standards for tax planning, and there will be more. So from my perspective, I would say this as a regulator, I think it has to be enforceable because you can set the standard for the well-meaning people who are maybe ill-informed or unintentionally do the wrong things, but there will always be some people who will try and flout it unless there's some kind of sanction. So I think the fact that we've developed this in a way that it's got regulatory teeth is a really important factor.
Yeah. And all that seems to point us in a slightly different view of the profession. So it's not just centred on the best interests of the client or even on the client interest, however that might be defined and implemented. But it is about the role of a professional in a broader setting with obligations to the public and the public interest. But that brings us back to the tension. So let's use that as a segue to outcome 3. And I'm not doing all 5, this is the last one. But it is about somebody being supported and empowered to uphold their ethical obligations. And if we have those dual obligations to client and to profession, public interest, how can that actually be supported in an environment that's driven by chargeable hours targets, fee targets, client retention, all those pressures that we know lawyers, particularly younger lawyers, can be subject to?
So I don't think this is that unlike the concept of a community pharmacy, where ultimately I'm a practicing pharmacist, I have a duty to provide those prescriptions and also have a duty to encourage the health and well-being of people who come through our door. But we are underfunded, and so we don't actually have enough money to stay open. So therefore, some people might say, well, every item that you sell is actually you're only doing that because you're making a profit out of it. So this is not an unusual tension, I don't think, but ultimately it's also about the concept of being a professional. And I've always thought it's a privilege to be a professional and to be amongst a body or a part of a professional body where actually, well, back in the olden days, where actually the regulator and the professional body were one in pharmacy, and so it was, a big deal to be cast out by the regulator and the professional body. I do think professional bodies have been weakened in a sense when we now have a professional body where you don't have to be a member of the professional body to be a member of the profession. So I think it's about strengthening the role of the profession and making it very important to be that profession. If you think about doctors have done this quite well, you know, it's an honour to be, not that we've not had some interesting doctors a long time, which pharmacists have swept up. I won't start talking about Shipman, but you know, there's a very much a camaraderie, I would say. I know that I can speak to a bunch of doctors and they will come together and have a very, almost like a very single thought out opinion when they present a united front, compared to a body of pharmacists where people always say to me, I don't know which group's talking to me now. That's the truth of it. So I think it's about that strengthening of what it means to be part of a profession that actually encourages people to go the right way.
So if you regard all of these different ways in which behaviour is somehow regulated, whether formally or loosely and informally, it is about changing that behaviour. And in many ways it is about curbing the self-interest of the individual to do whatever they might think they can do or get away with. Or there's a loyalty to their organisation because they're employed by them and they don't want to do anything that upsets that relationship. And the profession sort of gets left out of that conception of what it means to be a professional. I mean, I guess my question is, are we just clinging to a romantic and idealised notion of what it means to be a member of a profession in 2025?
I think perceptions are changing and expectations are, again, when I come back to what do people expect now? We're thinking more about sustainability. We're thinking more about ethics. We're thinking about investments that, you know, people are involved in. We had a huge amount when I was in the Royal Pharmaceutical Society. When I was chair, we had a huge push to for investments to be made ethical. You know, make sure they were ethical by our members. So I think it's very easy to cling to this romanticised concept of profession, but it stood us in good stead for a very long time. It's going to continue, and otherwise what sets us apart from anyone else? Why doesn't the person on the street just call themselves a solicitor and we crack on with it? You know, that's the difference between us. That's you. If you're going to hold yourself out as a solicitor, then being part of that profession is integral to that.
I just completely agree with you. I think it's incredibly important that we protect and nurture this idea of a profession, because yes, you have almost like a dual loyalty, don't you? You have the loyalty to your profession, which is in a way a duty to the greater good, you know, to the public interest, to society, and as part of your professional group. And then your duty to your organisation, which is a more narrow sort of focus. And I think it's incredibly beneficial to have both of those things. And this is what we're trying to do at the Institute of Directors in respect of directors, because directors haven't really had this professional linkage. You know, they have been individuals who have occupied the office of director at specific organisations. They haven't had this wider professional loyalty. And that's where I think the ethical dimension can sometimes not be so apparent, because you don't have that. And so by, for example, having a code of conduct for directors as a professional group, I think it's trying to create that. I thought there was this very interesting statement which was made during the whole post office saga. I don't know if you remember this. It was when Paul Venables, the CEO of the post office, I think was having a conversation with the chair, Alice Perkins, and was referring to the general counsel of the post office, who was on her way out, someone called Susan Crichton. And she said something along the lines of, her professional loyalties got in the way of her responsibility to the organisation. And I think, you know, when I heard that, I thought, well, that's exactly how it should be, because this is a potential, I mean, it didn't work very well in that instance, unfortunately, but it was at least a potential check and balance, and we should be very loath to want to get rid of that.
And it's refreshing to hear that view coming from the corporate side towards members of the profession. Sophie, accountants have arguably more direct links to serving the public, because they prepare public statements and they audit and so on. Do you feel any differently about the strength of that connection?
I think that's an interesting question. I suppose I would always say, well, the chartered accountancy profession was founded with a public interest duty. It's in our charter. It underlies everything that our profession stands for. But I think public interest, it's something that people talk about a lot, but do people really know what people mean by it? I think it's something that people claim that they are acting for if it suits their cause sometimes. There's perhaps a cynical view. But I think it's about taking the public interest and turning it into something that's real, that people understand. Well, what does that mean for how I conduct myself as a professional? And I suppose how we try to do that is our code of ethics is designed in such a way that it should mean that if a member follows what our code of ethics says, they will have met their public interest duty as a chartered accountant. And I think that's a really important linkage, because just saying to somebody you need to act in the public interest doesn't really get you very far. And actually there's a recent change coming internationally where it's been acknowledged that sometimes that won't be enough. That you could follow what our code of ethics says, and in extreme circumstances you may still not have met your public interest duty. And if you identify as a professional that you think you're still not meeting a public interest duty, you are obliged to take action and to seek advice from your professional body or regulator on what to do. Absolutely. So I'd say it's really, really core.
Yep. I can see Tanya's hovering, so I'm suspecting we've got some questions.
Yeah, we've had lots of questions generated in response to this.
Okay.
Someone's asked quite a bold question, what about the support needed when a professional wants to stand in front of an ethics train but is under intense pressure not to? So who do they turn to when it's an issue that's ultimately they might feel on them and their backbone alone? Someone's asked around, based on Thorin's comments about the shared stance by doctors with lawyers, does a large number of different legal professions and regulators dilute this effect and make it more difficult to achieve this support? We've also been asked a question around self-regulation through reporting. Could that be the answer to keeping ethics at the heart of legal practice? If so, training on the profession's reporting obligations would be a wise measure. A question actually for Dr. Barker, should the IOD become the Institute of Execs to include CROs and General Counsel?
So should it also encompass, well, a general counsel, of course, any of these roles can join the Institute of Directors, but as in their capacity as a director.
Okay.
But yes, they presumably have their own professional bodies which can pursue their own interests.
Yeah, we've also had quite a lot of feedback around things like leadership training being really important and rarely offered consistently in different professions. The training to improve leader well-being too is emphasised. As someone said, many individuals find themselves with management responsibilities without any particular guidance or skills-based support on how to carry out that kind of management role. I think some discussions were generated at the start of the discussion for this session around CPD training and welcoming a return to mandatory training, not specific courses but hours-based requirements, and a question around how likely that is to return, including a mandatory ethics requirement. And also a question for Sophie, I suppose, around whether the ICAEW course does sound good, the 1 hour ethics training, but someone's asked, is that really enough for 1 hour per year? And then there's a more sort of generic, broader question around how these outcomes will be tested from this consultation and could just be seen as another tick box course.
I'm happy to pick up the CPD question. So is 1 hour of ethics enough? Well, it's better than nothing, I think. I think if you make somebody do an hour and you make them do it every year, then it means that at least every 12 months somebody is stepping away from their client delivery work and they're thinking about ethics. I would say that the ethics course doesn't only have an hour of content. We got quite carried away in the first year. I think there's up to 12 hours of content there if somebody really wanted to go to town on it. And I think the extra material being produced every year, I think it's multiple 2 or 3 1-hour modules being produced. So I don't know if you can come up with a perfect number, but I think if somebody is doing at least 1 hour of ethics every year, that has a lot of benefit just in keeping it front and centre in a professional's mind.
Can I just add to that? So in pharmacy, we don't actually have any mandatory ethics training for revalidation each year, we call it, and we have to do 6 pieces, and it's some of them are reflecting on what you've done, and some of them are preparing for what you're going to look into effectively. And then there's a peer review as well, and that peer review asks you to reflect on, you know, how you've provided patient-centred care, for example. But there isn't actually anything directed specifically towards ethics, so I'm sure after this, my CPD will be changing next year.
Any questions in the room? Oh, yes. Sorry, we need a microphone.
Hi, I'm actually an accountant, and I mean, one thing we did see from the post office scandal was lawyers were picked on, but the accountants actually got away relatively, and some people do say the FRC actually needs to be able to have better powers. And, you know, some people have referred to a super regulator. I mean, like we said, we've got a lot of regulators, but, you know, some sort of super regulator I almost think is needed. And I speak from a personal experience. I was here this time last year, and, you know, there was this raft of guidance on investigations that the SRA have done. So I actually took a case to the SRA with a hell of a lot of evidence because I've actually done internal audit. The lawyer in question basically turned around, and even though a FTSE 100 company had a policy which said the lawyer was appointed to do it, she just turned around and said it had nothing to do with me, and the SRA literally closed it on that basis without actually investigating the policy, the evidence I provided, and I've done internal audit. So my problem is, if you're doing all of this guidance, I mean, I know the ICAW are actually enforcing it better, but if it's not being enforced, because, you know, I was shut down and I couldn't go any further, is there a need for a super regulator? And then also, like with the post office scandal, where there's a couple of, you know, a couple of different professions who've come about to cause something like this, the need for a super regulator and a better enforcement when the regulators aren't doing their job?
It's a very good question, and I'm going to say we haven't got time to address it now. But clearly, as you look at the way in which this guidance might play out, because it's aimed at a number of different regulators, the possibility of very different approaches being taken is there. And given that different legal professions do different things, that might be right. But I do think we need to look at what's the bedrock on which all of that is built, and it may need a sector-wide, more standardised approach. There was another question at the back, and I think that this will be the last. I'm sorry.
Thank you, Claire. My name is Elizabeth Davis. I'm chair of the I'm national chair of the Office for Legal Complaints that oversees the Legal Ombudsman. I'm really interested in what's the relationship between ethics and complaints, and that might be complaints at first tier, that might be complaints at second tier, that might be complaints in terms of fitness to practice, for example, just thinking of the pharmacist point. Because the question that's being asked is how can regulators and leaders keep ethics at the heart of legal practice? What if they don't? What are the sanctions, and where do complaints fit into that? Thank you, Stephen.
Anybody want to?
I suppose as the regulator, I should probably comment on complaints. Yeah, you need both sides of the coin. You have to set what is expected, and then there has to be proper investigation and enforcement where things have not been to that standard, and complaints from clients is a large source of that. So I suppose I think they're entirely interlinked, and at ICAW I think we deal with over 1,000 complaints a year, and they're all assessed, and the ones that meet the hurdle are investigated, and we have a full regulatory and disciplinary infrastructure made up of independent lay majority bodies who opine and decide on those. But I think you have to have both, don't you? And people say that is having more complaints a good sign or a bad sign? Well, obviously you don't want things to be going wrong, but it's important that people understand that they can complain and that they have faith in the complaints process and that the outcome of that complaints process is publicised.
I think we're probably at the end of the session, so thank you very much. I think there's a sense in which this guidance will be aimed at the regulators, not the regulated, but it is the behaviour of the practitioners that we need to change, not just want, we need it to change. we've got to be very careful, though, I think, that we focus on changing their behaviour, not what they think, because it's a very personal experience in deciding whether to behave ethically or even consciously deciding to behave unethically. So where the regulators focus their enforcement is, are we regulating what you think, or are we regulating what you do? And I hope it actually focused on the latter rather than the former. Otherwise, we're in some very, very deep constitutional difficulties. Do we? Oh. So apparently we've got 5 minutes I didn't know about.
Can I briefly challenge that? Now, I'm chair of the Legal Services Consumer Panel. I also chair the Taxation Disciplinary Board, and actually I can confirm what Sophie was saying about the way in which the regulators come down like a ton of bricks on people who don't comply with PCRT. But one of the things in terms of how people think that really does matter to me as the consumer representative on this issue is one particularly around the issue of dishonesty. Now, actually in this case, the case law in professional regulation is absolutely clear, and in terms of the conduct of the assorted disciplinary tribunals across certainly all the professional regulators I'm familiar with, which includes healthcare as well as tax and accountancy and looking inwards at the legal professions. I was extremely concerned very recently by a story in the Law Gazette about a particular case at the SDT which involved a trainee solicitor who ended up being struck off for some offence which related to dishonesty. I think it may have been something to do with documents to do with examinations or something like that. And the appropriate decision in terms of my reading the report was that they were removed or struck off. Mm-hmm. And that would be the convention across, I think, all professional regulators, and all the judgments in the High Court and the Appeal Court make it very clear that that's the appropriate thing to do. What shocked me was the response in terms of the comments section under the story. And I generally refrain from reading the kind of comments sections. But there were a string of solicitors who were saying this was unfair and essentially saying that dishonesty is not one of those things that should be at the heart of, I think, all professions. And I think that is a case where we are saying something. It's not just about behaviour, but it's actually about what people are thinking. And from the point of view of chairing the consumer panel, the absolutely irreducible expectation that we've got of the regulators is that they will, and of the professions, is that honesty is something which is at the heart of all professions. And what's more, I think in this, there are sorted judgments in the courts where the view has been taken that actually there is a higher standard expected of professionals, and certainly that's what I would concur with. But I think that's a matter of what people are thinking, not just about behaviour.
Yeah, but and I wasn't making that point. If somebody behaves dishonestly, then yes, they should be dealt with. But honesty and many other ethical values are just values. They are what I think. If the regulator tries to regulate what people think as opposed to how they follow up on their thoughts, I think they're on a hiding to nothing. And I've been looking at legal services regulation for 20 years now. I look back at what regulation was like in, Clementi's time, 2004. We've got a lot more regulation. We've got many more attempts to control and supervise what lawyers do. And it seems to me that we've ended up with less control and supervision over what actually happens. So it's a bit of be careful what you wish for, because you can go overboard, and that has costs, it has burdens, that creates friction, it affects consumers, it affects clients. I'm not saying we can't and shouldn't try, but I think there are some difficulties in how we get on that particular bus. And I'm getting a clear wave from the back, so I'm sorry. Time is up. Thank you.
Thank you very much for your a very engaging and interesting conversation. I think some of the things that came out of that is, but do we need a clearer set of rules, set of ethical rules, perhaps? We've spoken about collaboration quite a bit today and about comparing notes. Should the SRA, Bar Council and all the other regulators be talking to each other to see what best practices elsewhere, what works, what doesn't work? Can we collaborate more? I think that probably is something which needs to happen. But for me personally, the most interesting thing that came out of that was education. Do we need to educate more on ethics? The answer must be yes. As someone who is in the profession, I can tell you that when you go to, if I call it law school, as Americans would call it, you get taught about ethics. But very rarely do you get taught about ethics again. Rarely do lawyers end up looking at, if I call it the rule book again. So I think that's something that has to change, in my personal view. Very interesting to hear what accountants are now doing with CPD. I will be shocked if this time next year we are not saying that's happened, with at least with solicitors, probably barristers as well, because it seems such a good idea, perhaps more than an hour, but such a good idea to do, that I'll be amazed if we do not pick up on that. And surely it must be an action point. And from my point of view, I really hope that it is. Ethics is directly linked to trust. And if the public do not trust the legal profession, then we're on a very slippery slope. And I think if we deal with the ethical side, at the same time we deal partly with trust. So it's a very, very, in my view, important subject. We turn now to the theme of EDI and the role of regulation in encouraging a fair, healthy, diverse and inclusive legal profession. I'm joined now by the Legal Services Board's CEO, Craig Weston, who before joining the LSB was Director of Communications, Policy and Research at the Electoral Commission. Craig Weston.
Good afternoon, everybody. And I want to thank all of our speakers today for their participation, and indeed to you in the audience, both in the room and online, for your participation. It's really been a stimulating day. We've talked about two really, really important issues today and really explored the challenges that we face as a sector in addressing them, but also a real sense of the ambition that we have in this room and in the sector to really address those challenges and shoot for something much more stable and impressive as a sector in what we can deliver for the public and for the consumer. And I'm now really pleased to move us on to the third topic as Dean introduced, talk about EDI in the context of the sector. We're operating in a changing context, and I just wanted to reflect on that briefly before going into the England and Wales context. Reading daily media reports of the shifts of the global conversation about equality and diversity, and speaking with those who work in this space, there is a clear sense of apprehension and uncertainty, which I'm really picking up on. But what I'm also picking up on is a real sense of resilience and determination from those who are leading action, and we're going to hear more about that later today. Why do I mention this? Because I want to really reaffirm the LSB's commitment to this agenda in this context. This is not least because our founding legislation demands that we protect and promote the public and consumer interests. It demands that we encourage an independent, strong, diverse and effective legal profession. So this isn't optional, this is a statutory duty for us. But equality and diversity and a healthy professional culture are critical to supporting strong confidence and improved services. And this in turn will help create a sector which works more effectively for its employees, for its consumers, for citizens, as well as for the economy and for society more broadly. And of course, regulation is more than setting minimum standards for the profession and stepping in when something goes wrong, and we've been exploring that today. Effective regulation can really help to create more accessible routes for people to enter the profession and practice law. It can provide clear frameworks for ongoing training for lawyers and encourage strategies that promote equality and healthy professional and workplace cultures. So in this way, regulation is a key driver of positive change. Regulation can create a stronger, more outward-facing sector that will support positive outcomes for consumers and really help our economy and sector to thrive. We need to use our extensive data and evidence that we have on the issues facing our sector to lead effective action, impact and accountability. This will be critical to creating a legal profession that truly reflects the society that it serves, from entry-level positions through to the top levels of the profession. You've already heard about the work that we're doing on professional ethics and the consultation that we've launched today, and I really look forward to seeing your contributions to that. Later this year, we will also be consulting on proposed revised expectations for regulators to promote equality and boost diversity. As we embark on this next stage of our efforts on this agenda, we're really seeking to take and to influence more targeted and effective action amongst the regulators that we oversee that delivers long-term sustainable results for the profession and for the public that it serves. So our proposed approach will also include potential creative and innovative levers beyond our expectations for the regulators that we oversee to deliver our vision for equality, diversity and well-being in the profession. Regulation that is proportionate, targeted and supports sector growth can play a strong and positive role in driving change. We must ensure that regulation does everything it can within the bounds of its remit to create the strong, inclusive legal profession that the public deserves and society needs. But of course, as has also been the theme through our discussions this morning, regulation cannot do this alone. It will not be the only thing to address these systemic barriers. We will need to work in partnership with all of you in the room, those of you online, and those people not here today, to achieve these ambitions. Now more than ever, working in concert to take collective action is going to be vital. So we look forward to continuing that conversation in the lead up to, through and beyond the consultation that I've mentioned, and I look forward to participating in those discussions with you. So really to hand over to the next part of the session on this topic, I really want to introduce to you Professor Debbie Foster and Lizzie Hardy, who will reflect on the impact of the 2020 Legally Disabled Report on disability, equality and inclusion in the profession 5 years on. Debbie Foster, who's joining online, is Professor of Employment Relations and Diversity at Cardiff Business School and the academic lead for the original 2020 report. And Lizzie Hardy, who's joining us in the room, is an associate Everett Sutherland who specialises in employment law and diversity and inclusion issues and has also been a committee member of the Law Society's Disabled Solicitors Network since 2019. So while Lizzie joins us on the stage, we've also got a question for the audience to kick off discussions. So if our team could now really reveal that on the screen. So, around 16% of the UK working age population identifies disabled. What percentage of lawyers identifies disabled? Is it 20%, 15, 10, 5 or 2? So you can use the QR code as before to share your response, and I will now hand over to Debbie and Lizzie to reveal the answer and begin their discussions. Thank you.
Thank you. Thanks for that warm welcome. Nice to see you, everybody. What a privilege it is to be here today. I am hoping the tech is going to be on our side and Debbie is going to join us. I can't see her yet, but let's keep everything crossed. There she is. Hi, Debbie. You might be on mute.
No, I'm not.
She's in. Great, we're rolling. Look, I'm mindful that we've got 15 minutes to get through what we could talk about for about 15 hours. And I don't want the Oscar music to start playing and do an Adrian Brody. So we will kick off without any further ado. So Debbie is the real person who can talk to this research, which was fantastic and really game-changing for disabled lawyers in the profession. So Debbie, please talk to us about, firstly, why did you decide on the legal profession when you could have researched anything?
Yes, thank you, Lizzie. Is my volume okay? You can hear me all right?
Yeah, all good.
Lovely. Yeah, great. Thank you. Yes, well, looking at the legal profession, I was particularly interested in the fact that the legal profession had a lot of equality and diversity initiatives. But when I looked at it, I couldn't actually see any initiatives that were aimed at disabled people in the legal profession. And increasingly, when myself and my co-researcher, Natasha Hurst, looked at the reports and the literature around in this area, we just thought, well, disabled people seem to be unexpected. They're missing completely. So why was that? Given that the legal profession was doing quite a lot of diversity and inclusion work in other areas, such as gender, race, LGBTQ+, you know, sort of socioeconomic issues, why was disability absent? And as we talked to more and more people in the legal profession, it became apparent to us that there just weren't many visibly disabled people. And I don't think that is because there were very few disabled people around. In fact, what we discovered when we got talking to disabled people within the profession was that most of them had non-visible impairments or health conditions. So they often didn't present as a disabled person. And that also meant that they didn't have to self-identify as a disabled person. Now, the other side of the equation as to why we were interested in law was because unless disabled people are represented in a professional capacity, particularly like law, the operation of law can be affected. Bringing your lived experience to your practice, your professional practice, is really important. And it also brings insights about how to treat clients, how to treat litigants or defendants, and what kinds of issues are important to them to make them able to fully participate in the legal process. So these were some of the issues, and I'd like you did you reveal the outcome of the Slido? Because I don't remember you doing so.
I can't see it on here. It was going. We've certainly not revealed the correct answer yet. So if you want to, it's right in front of me. There we go. 47%, thank you, of people said it was 5%, they thought.
Okay. So that's similar to, I mean, we asked in one of our interviews and questionnaires about how many people reported the fact that they were disabled if they had a non-visible disability. So over 90% of respondents surveyed reported having a non-visible impairment. 70% exclusively reported a non-visible impairment. An additional 20% identified as disabled people with both visible and non-visible impairments. However, only 50 to 60% said they disclosed their non-visible impairment when applying for training, jobs or tenancies. And even when somebody had a visible disability, they often didn't declare the fact that they had a non-visible impairment as well. So we found that quite interesting that there are disabled people within the profession, but very few of them were declaring.
Well, so you've somewhat started already on my next question anyway, Debbie, which was going to be, in probably 3 minutes, which is going to be really difficult, can you sum up what you think the key for this is a huge research report, just to bury the lead with this. What do you think can you distill into sort of the next 3 minutes of the real key findings?
Yeah, well, I was going to say a little bit about what we did in terms of co-production, because we work with the Disabled Solicitors Network.
Sure.
And it was really important that we co-produce this research with disabled people within the profession. And because we were funded by disability rights organisations, they wanted us to demonstrate that disabled people within the profession were getting something out of the research, even if this was raised awareness, but also that they were full participants in the research, because within the disability rights movement, there's a saying, nothing about us without us. So, you need to integrate disabled people and their lived experiences into everything you do. And we used focus groups, we used interviews, and we eventually used a questionnaire. And the two key sort of areas I wanted to highlight in terms of findings was getting into the profession and getting on in the profession. So in terms of getting into the profession, we found a lot of solicitors had problems getting into the profession because of stereotyping, the assumption that they wouldn't be able to do certain jobs. These were sort of misconceptions, but also recruitment agencies who seem to filter out disabled candidates. At the bar, for example, we had a lot of barristers say that there were very stereotypical views of what you could and couldn't do as a disabled person. And this sort of was about how they presented themselves, or how they looked and sounded. And, you know, there are ways around this, and not all aspects of the legal profession you're standing up and doing advocacy. You might be doing, you know, a lot of office work behind the scenes, or working face to face with clients. So we have to see these as stereotypes and myths that need to be sort of addressed. Mm-hmm. There was also accessibility of employers. Lots of people said they turned up for interviews and they couldn't even get into the building. So why is it that firms aren't putting on their websites, you know, where you can get reasonable adjustments, how you get into a building, what sorts of facilities are available in the premises that they have? This should be really standard. And some areas of the legal profession were more accessible than others. So, and getting up into the profession, 58% of solicitors and paralegals surveyed believe their career and promotion prospects are inferior to non-disabled colleagues. Over 80% of respondents reported the process of requesting adjustments caused them stress and anxiety. And a huge number of people said they didn't request reasonable adjustments they were entitled to because they were fearful of being discriminated against. So we had a lot of people saying that even though they knew that they had an entitlement to adjustments, just simply self-identifying as disabled was going to disadvantage them in their career. Would you like me to say something about some of the recommendations?
We certainly can do. We might be skipping ahead a little bit, but we certainly can do. That's great.
Okay, so in terms of getting into the profession, we focused in our recommendations on things like work experience. Those disabled candidates who'd had prior work experience found it easier to get into the profession because they had that experience. So we were recommending that work experience placements and training places were reserved for disabled candidates simply because their underrepresentation was so out of kilter within the profession. So if you look at other sectors like the media, the BBC have earmarked certain roles for disabled candidates because they want to and they identify that they need to increase the representation of disabled people within the profession. Things like part-time provision of training contracts and part-time opportunities to do work. You know, as a lot of women in the profession have found, these can be problematic, but for disabled people, having that flexibility was essential. Mentoring and reverse mentoring from senior colleagues, and mentoring back to senior colleagues so you could share your lived experience was something that we also recommended because disabled people had found it useful. Monitoring and evaluating recruitment agencies and looking at the use of artificial intelligence in recruitment was something else that we spotlighted as important because of the fact that, you know, you could be using sort of ideal worker norms, sort of saying that you've got to have certain characteristics and not thinking about the adjustments you can make for disabled people. Accessibility in organisations is an anticipatory duty to think about accessibility for clients, but not for employees. So why is that? And should the regulator be saying, well, if you're doing it for clients, why are we not doing it for employees so we can increase the accessibility of disabled people in our profession? Getting on in the profession, we were thinking about things like disabled people having expectations of networking within the profession was really difficult. But also we found that a concept that we came up with was something called misplaced paternalism. We had a lot of disabled people tell us that they wanted to do challenging roles, but often their line managers were saying to them, well, you know, I didn't put you up for that, or I didn't put you forward for that because I thought I'd give you an easier role. But that was really, really patronising, and it also stopped them from getting on in terms of their career progression. And so thinking about those sorts of things. We were saying you've got to better understand the issues around progression and
Absolutely.
make reasonable adjustments during progression.
Yeah. And look, as I say, we could talk about this all day. You can tell it's a very meaty report. And what I would say is I would encourage you to either read the full report, which you can do online, or you can read a summary of the findings. So look, that paints a very bleak picture, or it did in 2020. The good news is lots of people were really encouraged by this report because it gave a lot of credibility and weight to what disabled professionals have been saying for a really long time and people's lived experiences, right? So with the help of Debbie and Natasha, we at the Law Society really had some motivation and some encouragement to get moving. I'm really conscious of time, so I'm going to do a very quick drive-by of everything we've been doing in the last 5 years, okay? But what I would say is, please do get online and have a look at what we've been doing. We've got some fantastic resources for your organisations, okay? And that includes things like easy wins for organisations. That's split into large organisations and small organisations, depending on where you come from. Best practice for reasonable adjustments, what does that look like? And that might be things, for example, like saying to everybody at interview stage, what do you need to thrive here at our organisation? We're not just singling out disabled people, okay? So things like that. We've since launched Project Rise, which is the project that I lead at the Law Society, and it looks to get part-time training, which was a big problem, as Debbie said, that was a barrier for entry into our profession. It looks to make that standard across our industry. So no longer will disabled trainees be prevented from entering the profession just because they can't work full-time. I'm going to leave on one question, Debbie. If you can say in one sentence, where do you think we're going? What is left to do?
Okay. Well, COVID was something that was really important, and the introduction of much more flexible working. Please do not let us backslide from some of the lessons that we learnt from COVID and the fact that the profession was much more accessible to a lot of disabled people. There's a lot to do on culture. There's a lot to do on reasonable adjustments still.
Absolutely. And mine is, well, to echo that really sustaining momentum with where we have gone and not to backslide. And we need a culture change. I noticed from the notes that someone has already said that this morning, but we really need a culture change in how we look at DEI more generally, and certainly to not be swayed by our American cousins where there seems to be potentially a shift change. Hopefully that's not going to be the same for us. Thank you so much. Appreciate your time.
Thank you.
Thank you very much for that. Clearly a really important report, which I don't know about you, but I found some of those things really alarming, actually, that there are really law firms out there that are discriminating in the way that that report shows. That's very alarming. And hopefully this is not a subject which is sidetracked. It's a very important subject. And hopefully there'll be more improvements, more change in this area. We want to look now at leading effective action, impact and accountability to advance equality and diversity in the legal profession. And to chair the discussion, I'm delighted to introduce Patrick McCann, the chair of the City of London Law Society and CEO of City Century. Patrick qualified as a solicitor in 1992 and has previously been the head of learning at 4 law firms. He founded Social Welfare Solicitor Qualification Fund and was recognised as Champion of the Year at the 2024 UK Legal Linked Influencer and was a special mention recipient at the 2024 British LBGT Awards. Welcome to Patrick.
He's given the game away about me being gay, hasn't he? That's a bit of a shame. Never mind, coming out. I'm joined by 5 gorgeous panellists who are going to just come up, and this is going to jim into someone else's face, I'm hoping. While that happens, can you all come up? So Sarah, Rena, Natasha, Liz, and Olive, and I am, in fact, I'm not the chair of the City of London Law Society Training Committee because I stopped being that at 10 a.m. today at our last committee meeting. But I have worked in 5 big law firms, and I taught aerobics in Allen and Overy for 20 years. So I think that counts as well. And I have set up a couple of things that I think help people into and in the profession. And as a learning professional, whenever there's a problem, training is always the cause and the solution to the problem. So we are involved in a number of these things. I'm going to get you to introduce yourselves when you answer a question, if that's all right. And what I'd be particularly interested in is your thing in the DE&I health type space. So the heading for this is community collaboration to improve access to justice. What can we learn and what's holding others back? That's quite a catchy title. And I think what that is can we be a decent society, and what do we do in the context of all this anti-wokery nonsense and cruel stuff that we're having to deal with. We would like this session to have levels of interactivity, particularly using Slido, and we will be coming to a couple of polls and questions that we'll ask you to answer. But the main thing for me is that what we would like you to do at the end of this session is to type into Slido what you're going to do to help DE&I mental health in the legal sector particularly. There's a lot of chat and not so much doing sometimes, and I think we've heard today from a number of people it's not about something up here, it's about everybody doing something. So I'm very much hoping you will be part of that space. So this is about the systemic barriers that prevent a fair, diverse, healthy and inclusive profession in law. By the way, I retired on the 31st of January. I'm quite pleased, actually. Quite pleased not to be in a big corporate at the moment. And we do want to get a little bit beyond the data. And the focus of the discussion will be how we lead action for sustainable results and sort of drive accountability and, I think, cooperation in the sector. And what we really want to do is make sure that we hear from you both online and at home as we go to. And my bits, in the DE&I space is social mobility, entry into the profession, queer people. That's sort of, and anybody being bullied. Can't stand that. So that's my sort of thing. And we really want to know how we can achieve this ambition with courage, confidence, and success, given the pressures we face in the sector, and particularly, I think, in the context of current efforts to undermine the importance and efficacy of DE&I. Well, it doesn't feel very cool this year, does it? The DE&I stuff feels very under threat. So I'm going to go to the first question. If you could go to this QR code on Slido, I'm very much hoping that this is going to come up as a question, and it needs a typed response. So what for you are the greatest challenges in advancing equality, encouraging diversity, and promoting a healthy and inclusive culture in the legal profession right now? I think we're going to get some answers here. It's very exciting. Panellists, if you also want to go on Slido, that would be, but you didn't bring your phones. Great. Data, evaluation on what works, preconceived opinions. If anybody wants to type on my phone, but just be careful what you slide on, because there's all sorts on it. Well, I have weekends, don't I? I have weekends. Recruitment processes, a lack of collaboration, what regulators can influence and control, intersectionality of socio-economic disadvantage, huge resistance and backlash from legal, fear of what's happening in the world, apathy, structural bias, lack of visible data. You'll only be able to see this if you've got your Slido open. Would you like to have my Slido? Because I'm very happy to give it to you. Apathy, immigration system itself, sponsor, imposter syndrome, lack of role models, conservatism, interest by those who don't feel DE&I impacts them, pressure of targets. But I feel that's enough now. Thank you. Wigs, I'm not sure what's going on there. It's not a wig. Labelling, costs of training, greater, better allocation of resources, billable hours, cumbersome bureaucracy, assumption that... Can you stop now? Please stop. Enough. So just some reactions from whoever might want to react on that in the panel. If you could say your name and your thing in the DE&I healthy living space. I'm going to go with Rena.
Yeah, okay. Hello, everybody. I'm Rena Palmer. I'm counsel at Freshfields and also chair of the Law Society's Disabled Solicitors Network. So I do a lot of advocacy in the disability and... Can't hear you.
Can we have the mic might not be on.
There we go. Is that any better?
Hold it for there.
Testing, is that working? Yes. Okay. Sorry, Patrick. So, very quickly, Rena Palmer, Counsel at Freshfields, Chair of the Law Society's Disabled Solicitors Network. I'm a big advocate for disability and neurodivergency.
And so reactions to what you've
Yeah, I mean, I would say, for me, the billable hours model is massive. I know we're going to talk about that a little bit more, so I won't delve into it too much now. I think also getting in when you come from marginalised communities is really, really tough. I can see people nodding their heads. It's tough because...
I love this. This is better. This is much better.
Do you want it?
No, go for it. Go for it. Now sing.
I feel like I need that whole word map back up again. But there's a lot of people that just don't think about coming into the profession because they don't think it's a place for them. They don't see people that look like them, that sound like them. That's definitely true in the disability space, but also in terms of race and ethnicity and other factors. So it resonates.
Fab. I'm going to close that there because it's brilliant. We've got a second question for you. I love this question. By the way, thank you so much for Gavin for corralling this. We look like a Crime Watch panel, don't we? It's just it's a little bit of a worry. Gavin, the next question we had, and again, if you could go, I think this will be a poll in Slido. How valued, supported, and this is a bit loaded, I'm just going to say that. How valued, supported and recognised do you feel for your work to drive equality, diversity, wellbeing and inclusion in the workplace and or in the wider legal selection? You've got three options, very, slightly or not at all. So it's quite exciting. We're half, slightly, not at all, very, someone's got a good job, that's great, not at all. So it looks like we're slightly valued and supported. So I'm going to close this in about 10 seconds, otherwise I'm going to be hypnotised by the numbers going up and down. So if we could close that now, the results are slightly valued and supported at 47%. That sounds like a meh sort of experience. Very, which sounds great, at 31%, and not at all in the 24%. I'd like to, Liz, I haven't told you I'm going to do this, but I'm going to come to you and then I'll go to Olive just for a response on what you're seeing there around value, support and recognition.
I think it's very telling, isn't it, that actually almost a quarter of people feel that they're not recognised or valued for the work that they're doing in this space, probably reflected by all the barriers that came up on what we saw on the first slide. I think it is encouraging that 30% do feel that they are valued. I think that's positive. It would be interesting if we'd done this 5 years ago, if we'd seen any difference. But I think it's a shame that we're not seeing that at 100%.
And Liz, could you just talk just a little bit about
the work you do? I forgot to say who I am. I'm Elizabeth Rimmer. I'm from Law Care. We're the mental health charity that support everybody working in the legal sector across the UK.
Great. And Olivia, if I could get a quick introduction for you and then just your reaction, particularly the work that you're doing.
Yeah, I'm Olive. I'm a solicitor at Rights of Women, which is a legal advice charity that provides advice across immigration, employment law, family law and criminal law. What was the question again?
The question is, what's your response to what's on there?
Yeah, I think Elizabeth has said it all. It's really upsetting that 24% feel that they're not at all valued. But I also wonder whether how much of that is reflective of the variation across the legal sector in terms of workplaces, work environments, and the difference in approach that you will find in a culture in different law firms. It's because it's possible to do it. 29% said very. It's possible for it to happen. You have to create the culture that enables it.
And unscripted, Sarah, can I just come to you for a response on this? Because you're local government, so if you could just say who you are and all that sort of stuff.
Hello, my name's Sarah Harriott and I work at West Northamptonshire Council, contracts and procurement lawyer there, and I have a vested interest in this space, very similar to what Rena said. I've felt those barriers, and what I do is I post on LinkedIn. Anyone who wants to follow me is more than welcome. Just about my experiences, so hopefully I can get to share some of those today. It's really, I'm coming at this from a lawyers and local government's perspective. I sit on their board as well, and the will is very much there in local government. We've got the public sector equality duty, but it's as some of those comments said, it's the lack of commitment, the resources, yeah, and it's just really, it's disheartening to see the results today, I think.
Thank you. It's really interesting. Actually, those results are higher than I thought. They're better than I thought they would be.
Okay, I'll
I have
be
to
less
say,
disheartened.
when I'm speaking to big law D&I departments, they look battered, frankly, and they're trying to do the good work, but they do look battered. And I will come to you, Natasha. I'm now going to go back onto the script, so it's slightly less scary for us now because we're going to be following what was asked. So this is our first sort of panel discussion question one. So, and this one will come to Liz and Olive and Rena. What are the greatest challenges that we face in delivering on our ambitions for a fair, diverse, healthy and inclusive profession? And if you want to go there, how do you think we can best navigate those challenges? So maybe if I start with Liz and then go to Olive and then Rena.
Okay, I think picking up on something Rena said around the billable hour model, I think there's something inherent in the way we work in law and what we value and how we measure success. We tend to value the time spent on doing tasks. The people that make it to the top are the ones who are really good at putting those hours in and getting those tasks done. I think that drives behavior where we don't recognize and value the other things that people do in the workplace when we're talking about work around diversity, inclusion, and equity. And I think that behavior also drives a sense of competition with others. We're not that collaborative, really, in the legal sector. We're looking out for ourselves often. Am I going to meet my target? Am I going to get that next promotion? So I think we discourage, in a way, by the way we work and what we value, we're actually discouraging those behaviors that would drive a more inclusive and diverse profession. And I think that's something that we really need to address in terms of what we actually reward in law. And I think another aspect of that is I think there's limited capacity and resource. We need to remember that the vast majority of law firms and workplaces across our nation are not the top 200 law firms where they may have people like Patrick who've been advocates and leading that work, or people like Rena. A lot of this work is falling on people on top of the day job. And so what happens is the day job takes priority because that's what you've got to be delivered. That's what gets measured in terms of what you deliver. So you're expected to do all of this on top of something else. So I think when there's a lot of other competing obligations for your time, I think that's a challenge. And we have that lack of capacity and that lack of expertise, if you want to say, that education or that understanding, actually knowing how to do any of this, I think is a limitation as well that we have in our sector.
Liz, thank you. Olive, if I could come to you.
Yeah, I thought I would go really big problem with this question. I think the greatest challenge with equity and diversity in the profession is that we have to recognise, and sometimes we have to just name, the structural and institutionalised discrimination that certain members of the profession experience. In fact, probably really the majority of the profession, when you add everybody up, experience. And when we talk about the profession, especially in the current political climate and how equity and diversity is facing a real political, let's say, moment. When we are talking about it, we have to name why we are doing it. There are members of our profession, so we don't other. When we talk about DEI, we're not othering people. We are members of the profession. There are members of the profession who experience that real structural and institutionalized discrimination for no other reason than because of the color of their skin, their gender, etc., etc. And we all have a responsibility to challenge ourselves to try and break down those barriers. So it's big challenge, but I think sometimes when we get into the nitty-gritty, we forget to name what the big challenge is. And in the current political climate, I think we do have to remember why we are talking about this in the first place.
Thank you so much. I'm going to turn to you now, Rena.
Yeah. What Elizabeth and Olive said resonates so much with me. I guess my point is the burden of driving progress is often placed on the shoulders of those that are marginalised rather than it being seen as a systemic and organisational responsibility.
time and effort spent on DEI initiatives are not valued, rewarded in the way they should be, which kind of draws on Elizabeth's earlier comments about the billable hours model. But those that are marginalised are the ones that are having to perform at a high level, but also push for grassroots change. And speaking from experience, that's tough. It takes a lot out of you. Those challenges are compounded by a lack of diversity in leadership. So those that are most affected by the status quo are not the ones that are at the boardroom table making decisions that affect their future, and that needs to change. So my point is that diversity advocates and champions, particularly those from marginalised communities, need to be recognised for the extra work that they do. They need to be given the resources, the tools, the support to succeed and thrive and perform. And that means sharing the load. And I think there is really a kind of a fundamental lack of understanding that a positive culture requires everybody to get involved. It requires everyone to be an active ally and to do their bit to drive cultural change. And so unfortunately, those from marginalised communities end up in a cycle where they end up having to work really hard on the day job and show up. They also feel the burden of having to drive change. And that leads to burnout, and it's not sustainable.
Thank you. And I just wanted to add, just in terms of navigating a challenge, one of the things that I've been really pleased to see, I'm a people person, so I like working with lots of people. And one of my projects is 50 law firms who have come together, really competitive law firms, to recruit in solicitor apprentices. And we're now recruiting about 130, I think, to start in September. It's been really interesting to see that you can reach across and find the good people in other organisations. And that's just been lovely. And I've done that even in the queer space. In terms of recruiting people in and then developing them. I've managed to get the 5 Magic Circle firms to work together. That's just unheard of. But it does happen, and it can be fun. Let's go on to number 2. Natasha, you are now responsible for telling us all about how we can embed and drive effective long-term cultural and behavioural change in the profession. And are there any current incentives and accountability structures in the sector enough to achieve this? There's always a short question, isn't there? Achieve this change. Go for it, Natasha. Who wrote these questions?
What I'll do is I'll start off by introducing myself, because I haven't spoken on this panel. You saved the best and possibly the most controversial to last. I'm a barrister. I practice in from Garden Court Chambers. In terms of EDI space and work that I do, I'm an elected member of the Bar Council. I sit on its Equality, Diversity and Social Mobility Committee and its race panel. I am the founder and the chair of the Black Barristers Network. I sit on the Honourable Society of Lincoln's Inn's EDI committee. I think I also sit on Anglia Ruskin University's Legal Advisory Board. They're the university that gave me my honorary doctorate. And I probably missed something. But oh yes, because I'm a bar council member, I'm co-opted onto the FLBA as well, etc., etc. So many committees. So I absolutely agree a lot with what Rena was saying before about the burden being placed on the individuals that are experiencing the discrimination to try and tackle it. I sit here before you all today, having not had dinner last night because I got my brief and papers in late. Spending last night and today drafting and preparing for this conference. I've not had lunch either. Not a piece of food has gone through my lips. So that should give you an idea of how much work some of us are putting in to try and tackle these issues in the profession. Now, big question. How do we embed and drive effective long-term cultural and behavioural change? Thank you. I think the first thing we need to do is acknowledge the world that we live in. I have spoken, sitting right here at the King's Fund before, on a similar panel a few years ago, having the same conversation about equality and diversity and focusing very much on the tools and the things that we can do to support. I will come on to those in a moment. But since that time, I've got a bit older. I've got more jaded. I've seen life and how it works, and I have some things to say. We live in a racist, sexist, ableist, homophobic, and transphobic society. The first thing we need to do is acknowledge that. What we're doing in this space of EDI is we're trying to put little plasters on what is effectively an unfair, unjust, and broken world. And the reason why I'm taking it out to society is because, as a barrister, it is consumers, lay clients, who instruct us. They too live in said society, and they too have the similar stereotypes, positive and negative, in their minds when they're choosing who to instruct. On race, it's a social construct. It's in this hierarchy that's been placed to say that certain people, white people, are at the top, and black people at the bottom, and then the Asian people are somewhere in the middle, right? And then with that, you look back at the history of things like slavery, where black people were treated as cattle. We weren't seen as human beings. We were sold, traded, right? Those views and those thoughts are still, we still have those sorts of shockwaves in our society today. That's how we get these negative stereotypes of black people being lazy, not being smart, not being polished, not being professional, etc. And then there are certain other types of individuals who have the benefit of positive stereotypes, of being intellectual, being persuasive, charismatic, charming, white people. Those are some of the thoughts in the back of the minds of some of the people who are deciding whether or not to take us on as pupils, whether or not to take us on as tenants, whether or not to instruct us, either from the solicitor point or directly from the lay client, whether or not to appoint us onto panels, government panels like the Attorney General panels, whether or not to give us silk so that we can take silk and become King's Counsel, or whether or not to give us a judicial appointment. What do we do to tackle that? I think the first thing that we need to do is we need to acknowledge it. The second thing we need to do is we need to look at the tools that already exist, that have been produced in particular from the Bar Council, in order to tackle this issue. I spoke at the last conference about target setting. I spoke about action plans. I talked about positive action. There are guides that my panels that I've sat on the Bar Council have produced, and I implore everybody to look at those. And we've also discussed allocation of work at length and monitoring and analysing that. There are guides in respect of doing it in the context of gender and also in the context of race. Those are online. I implore everybody to look at that. However, I'm conscious, and I have been for some time, that there's only so much the bar can do in isolation. So, for example, we bang on about the allocation of work. We need to analyse that. We need to make sure the clerks are doing things properly, etc., which is great, but there's only so much that they can do. When a solicitor comes in and says, looking for counsel for this kind of case, our clerks put forward a list of options of counsel that are available, and then it's left to the other side. What's happening on that side to make sure that the decision that is made on who's going to be instructed is fair? It's not, it's free of bias. It's actually made on the basis of the skills and the quality of the advocate, not because of the colour of their skin or the gender that they have. Who's going to do that? We can't do it alone. So as a profession, we need to come together to talk about it.
Thank you, Natasha. Sarah, I'm going to give you the opportunity to speak to this a little bit as well.
I think just picking up on the points I think both Oliver and Rena made, I think it's every action counts. That was the theme of Race Equality Week this year. I think especially to people coming into the profession, and I suppose that's where I really struggled. Just an example, went to an interview, you're told to give an example of leadership. I'd co-founded a African Caribbean Society at uni. I thought, great, I'm prepared. I hadn't even got to my leadership question, but, oh, I can see you've got this on your CV. I just want to check, have you got a chip on your shoulder? And it I just can't tell you how much of an impact. I was second year of uni, applying for training contracts. And just you think, I suppose I've lulled myself into a false sense of security put my head down over the years, thought this sort of thing doesn't happen now, but obviously these reports have started to come out. I think the one that affected me most was in 2020 when I first saw Stephanie Boyce speak. Lovely to see her last night. But yeah, that just broke my heart that so much is still going on in the profession that's not right. So I think, I can't remember what I was saying, but it's realising that the small things lead to the big things, I think, and acknowledging privilege, etc., etc. So much to say.
Thank you so much, Sarah.
Yeah.
Liz, can I just ask you, just in the mental health space, sorry, I'm not saying that that's the only box, but let's use that for the moment. Just what have you seen that drives change successfully and sustainably, if anything?
Gosh, big question.
And you've only got 90 seconds.
90. I think we've been talking about a lot today. I think we need to look at regulatory change and in how we incentivize organizations and people to change their behavior, I think is one thing. I think education and training is absolutely critical, starting right on the pathway into your legal career, but that needs to marry up with what happens when you get into practice. We need to join that up. I was delighted to hear about what, I know some people think 1 hour is not enough of ethics training for accountants, but it's something, and that's something that's required in practice. So I think we need to look at that. And I think the big piece is around accountability. We need to hold people to account. There's a lot of talk, there's been a lot of initiatives, they've been going on for decades, but we don't seem to have really shifted the dial. So I think we need to work out what are those accountability measures and how do we hold people to account for what needs to change and actually seeing it change.
Thank you so much, Liz, and delivered on time. Well done. That's super. Just because you've opened that door a little bit, and you said about measurement, the thing that we don't seem to measure is whether people are kind and whether they're decent and whether they are human beings that you'd want to spend time with. I would love, for example, for there to be some sort of measurement that is, what do your colleagues' families say about you? What do they hear about you? What is it that people are saying about you? Because I think we'd be absolutely horrified, most of us, to hear that stuff. You know, that sort of measurement, I know it's not possible, but that sort of measurement, I think, would be... We talk about KPIs, we talk about billing, we talk about clients that you're bringing in, we talk about deals that you do across jurisdictions, but we don't say, have you been kind? Have you been nice to people?
Can I feedback just a little point on that? Because one of the things I was going to raise was around, rights of women. We very much work on the basis that we are implementing trauma-informed legal practice. Our clients are overwhelmingly women who have experienced some form of violence against women and girls. They are highly traumatized. As a result of that, we work with them in ways that are trauma-informed. And there are moves within the profession to improve the way in which we do that. It's very much related internally as well. It impacts the way in which we interact with each other. It impacts the fact that we recognize the roles advisors have in terms of their interactions with clients and each other. And you don't have to be the type of legal provider who is providing direct legal services to very vulnerable people to have for there to be a benefit to working in trauma-informed ways. It also impacts things like, one of the areas we work in is employment law. We would love it if lawyers who are dealing with bullying and harassment complaints were doing that in a trauma-informed way. They should be. And it is one of the ways for us that's really important in terms of ensuring that a lot of it's kindness. That is a big part of what it's about, but it's providing a structure for how do you be kind, essentially.
Olive, thank you. We're going to move on to the next section, and this is where we would like you to, again, interact with Slido. We're a community here. I think we're all trying to help each other. I think we're trying not to compete with each other too much. And so part of that would be knowledge sharing, and part of knowledge sharing is people telling us things that they think have worked and that have helped. So the question we'd like you to begin to answer, and the panel will also speak to it as well, is can you, it says rather aggressively, share examples. I think it's please share examples of effective practice that you've led or seen in the sector. And we're really looking for stuff that has actually worked, which would be great. So if I could pass that down to, I'm going to start with Sarah, and then I'm going to go to Olive. you standing there makes me think that there's something that you're going to say.
There are some questions,
So,
but we
excellent.
can come to them at the end.
Let's do this one, and then we'll come back to you. So I'm going to go to Sarah, and then if I may go to Olive.
Brilliant. So where the council where I'm at now, we are a new legal service. We were one of the, it's not a secret, we were one of the first authorities to fall into challenging financial times. And as a result of that, we built up a new legal service. I can't speak highly enough of our monitoring officer, Sarah Hall. It's embedded in our structure. We've just been encouraged so much with the mentoring, the opportunity. So it's completely changed my life. I'd say that's an amazing example, good practice. Also, as I mentioned, I sit on the board of lawyers and local government. So we have EDI non-exec director. We embed it in everything we do. We try and make our conferences as inclusive as possible. We're always looking for, I'm here for intelligence today, basically, as well. We're always looking at ways that we can improve and make the legal, promote local government law and also make it as inclusive as accessible as possible. I would also mention at this point, Work Experience Week, if you've got anyone who might be studying out there interested in local authority law, follow us on LinkedIn, and its applications are open to get a bit of experience at a local authority.
Nice plug there.
Well
done. I think I'm going to go down to Olive.
I think I jumped ahead of myself a little bit because when you were talking about kindness, I thought, I have to get trauma-informed practice in when you're talking about kindness. But I think it is a very effective way of shifting the culture within an organisation, and it's not difficult to do once you understand the benefit of it and what it actually looks like. And part of doing that is providing you, we were talking today about accountability, and accountability is absolutely fundamental, and the regulators are a really important part of that. But also there's something about the way in which you hold people accountable, because if lawyers are not able to learn from the disciplinary proceedings, essentially, or the mistakes that they make, then all you're going to end up with is a group of lawyers who are constantly defensive about change and about new things. So accountability is very important, and obviously really bad practice people need to be held properly accountable for that, but also there are ways in which you can hold people accountable that also brings them with you.
Thank you. Natasha, have you seen anything work? One example of something that you've been impressed by?
I wanted to respond with no, like the first person in the poll, but there was two things that I was thinking of. I'm going to focus on one at the moment. 10K black interns. I think that's been a really good project. However, what I would say is that it's low-hanging fruit. Often when it comes to EDI stuff, people focus on access and trying to increase access. They don't focus on tackling the issues that people have once they're in the profession. And when I look at progression and how that's going, it's not going very well, in particular when it comes to race. So, for example, every year when the KC appointments comes out, the list comes out, we normally look through and scout to see, any black people been taken on, blah, blah, blah. This year, luckily, they also produced the statistics alongside it. And I was like, thank you so much, KC Appointments Commission. 10 black applicants applied, none of them.
Got through.
None of them. I sit here I can't tell you, how disappointed, how shocked, how upset and how angry I am when I'm not seeing any change for those of us who are already in the profession. People love to grab onto, let's bring us in, but I always keep banging on. There is no point in bringing us in if we're earning the least, we're not progressing, we're the ones that complain the most about discrimination and harassment being put upon us. It's exhausting. If you just look at the figures from the Race at the Bar report recently in terms of disparity of earnings, which is pretty bad. Let's pick silks for an example. For silks, the median earnings, for white silks declared this time last year, because we're at ATP point, was £453,864. For black silks, it was £253,001. Why am I here? Why should I continue to be in this profession when the ceiling is not glass, it's concrete, and it's not moving? Judicial appointments, black judges, 1% every year, 1%, 1%. And the thing is when it comes into recognition, which was the question that was mentioned before in terms of the work that we're doing, like I said, it's those of us who are facing the problems that tend to be doing the most work. We don't get the recognition. At the bar, most of us that are doing it, we're not employed. So when we're doing this stuff, we're doing it for free. When I'm doing this stuff, it's actually at a detriment to my practice, the amount of money that I've lost or that I could have been earning from working, that I've been doing this EDI stuff, and things aren't really changing, and the only thing that we're tackling is low-hanging fruit. I think you can tell. I'm tired. I'm very tired. So yes, there are some initiatives that I've seen, not enough. And when it comes to what needs to happen, like I said previously when I spoke here, we need teeth. I know that the regulator, the BSB, has tried to change the equality rules. I don't think they did it in the right way, but we need teeth, and we need the Bar Council and the Law Society to come together and also point the fingers at the Judicial Appointments Commission and the Casey Appointments Commission to sort this out.
Natasha, thank you. You've painted a bleak but accurate, I'm sure, picture. So thank you for that. More to be done, and more probably to be done by people that aren't necessarily in this room, and for whom I think, in terms of D&I, the way I think of it is layers, and people have layers to contend with to get to the success bit. And the more layers you have, yes, the more skilled you become, but the more difficult it is, the more exhausted you get. I have a slightly different view in the queer space, which is because I've had queer done to me by various good-meaning people over the decades, and the whole rainbow washing thing has been done, I actually like to reclaim that and have queer people doing it, directing it, and doing some of the work, just because I've seen some of the stuff and I'm like, that's not what's really going on for us. But it's good that we have these views. I'm going to just hand over to you, but just before I do, what we'd really like is on the next bit of the Slido. Do you remember I said at the beginning, we'd really like you to commit to one thing you are going to do. You know, bear in mind how tired Natasha is. Bear in mind what Rena was saying. Bear in mind I'm retired, so I'm no use to anybody anymore. Can't do it all. Can't do it all. I've got to spend time with the dogs. Maybe if you could go to your bit. Thank you,
sure,
sir.
Patrick. Thank you. So while people
by the way, I thought you were brilliant before.
Oh,
yeah,
thank you.
No, I really did. The way you managed to corral all that in was wonderful. Didn't I say that to you, Rena?
Yeah, well, we've got loads of questions here. So while people are answering the question live, I think I'll point out a few. There are a series, as I said. I do think they're quite important, so I'll throw them out there for you. And whichever you think are the most important or salient, feel free to answer. So we've got an observation here. Perhaps firms should be encouraged to match pound for pound what they spend on marketing with what they spend on EDI initiatives, as a suggestion. Someone said the majority of people working in social welfare law and public interest law are often from marginalised backgrounds. How can we support those entering this part of the profession? Someone noted that, or asked the question, are the issues faced by DEI lawyers mirrored in the experiences of DEI service users when trying to access legal services? Which is a really important question. Is that reflected in the poorer outcomes experienced by those groups? Some other questions as well. How do we incentivise white, male, able-bodied, straight lawyers to step aside and make space for others? Are there any specific suggestions? Are there restrictive dress codes from law firms, hairstyles, etc.? And that's it, I think, for now. And also, what can government do to better support and work with the sector to improve diversity? So lots of really important, interesting questions.
Can I take one of them at least? So social welfare lawyers trying to get into the industry. I've set up a fund called the Social Welfare Solicitors Qualification Fund. We've raised 1.3 million. We have enough for 121 people to have their solicitors' exams, the course and the assessments paid for. We do not have enough people applying. We've managed this year to raise more money than we've spent, so that's ridiculous. So if any of you know any people in that space, please let me. Government, first of all, thank God we've changed the government. I'm not supposed to be, but I literally sat in a room where Mike Freer, were you at that one, Minister of Justice, had a go at lambasting the legal industry for not doing more around the DE&I space. The way he introduced himself was to say, I'm a gay guy, but I don't believe in DE&I, and I hate pronouns, and no one should be forced to use the women's toilet, or whatever it was. And that culture was really unhelpful. Thank God Kemi Badenoch's nowhere close. But that, and reform, but that is a concern. I do have a real concern about government coming from the other side of the thing. I will just do the dress code one as well, because I want to. So I wear nails. I wear them because I like them and because you get 45 minutes of not really being able to do anything in that time. And my nail artist, Sam, she's Vietnamese. She doesn't care about me, so she doesn't want to talk to me, so it's fine. But I do it more because I want people to see that you can be old and senior and relatively successful and be different and give a different vibe. And I have people talk to me about stuff like this. The other thing I did want to say is what I have loved and I think is the change is the use of social media, and particularly LinkedIn, and how people like Liz, Rena, and Sarah they put love out there. They put stuff that questions things. And I honestly believe that is changing the conversation, is changing society. By the way, we all want more followers, so please do follow us on LinkedIn. Who wants to answer any of the others? So we've got. Should we do D&I marketing? Budgets should be the same. Should we do? Oh, my writing. What can we do to get?
I can pitch in on one.
Do the straight white men one.
I'm not going to do that one. No, sorry. I'm going to talk about the client experience, because I think organisations that are active in this space often focus on internal initiatives, but they're not thinking about how to take that learning to ensure a more inclusive client experience. And what are we here to do? We're here to serve communities.
We are.
So we need to interrogate that a little bit more. I think more needs to be done there, especially in terms of accessibility, which I think was mentioned earlier.
Thank you. Can I have more things going on to the Slido? Can I have one thing from each of us really quickly? So it's 15 words or fewer. Back of a postcard thing. What would you pose as one challenge to leaders in the sector? Which I think is what should they be doing essentially. I'll start. I think we should firebomb all partner dining rooms. I think they're really elitist and horrible. I said that to the managing partner, he wasn't happy. But I hate that we have that elitism in big law things.
Shall I go next? Critically assess the diversity of the teams that are leading diversity initiatives. Think about who is not in the room, not at the table, involve them. We talked about co-production earlier. It's really important to have those people as part of the discussion to evolve policy and organisational change.
Nothing about us without us.
Exactly.
Sarah.
It's interesting.
I'm going to do creeping death, which is going to go down.
Yeah. Sorry, I don't know about this big law business, but it's not quite like that. But obviously, our statistics are a little bit better. I just wanted to add, but we've still got a long way to go in local government. I think my call to action is a little bit vague, but hopefully you'll understand what I mean. One difference you can make to someone entering the profession, wondering if it's for them.
Thank you. Liz?
I'm going to be naughty and do two.
Oh.
First, sorry, it's my opportunity. First is my shameless plug for Law Care's Life of the Law study, which you may have seen that we're doing, which is actually addressing a lot of the issues that we're talking about. Our study closes on the 21st of March. You can go to our website, please fill it in, and share it wide with everybody that you know. So that's my shameless plug for Life of the Law. My other thing would be to actually look at yourself. I think all of this starts with me, it starts with you, it starts with what we do every day in our own behaviour. So I would say to a leader, think about how you behave and how you show up at work and what your behaviour says to the other people around you.
Natasha?
I think what I would say is challenge poor behaviours. I was actually going to say close the earnings gap, but I'll pause on that one. I think challenge poor behaviours will affect everything. So not just in terms of interactions that we have as lawyers amongst each other or clients, etc. I think it would help in respect of when it comes to client briefing. Because I have a feeling there may be some times where clients may make decisions on barristers that are not exactly free of bias. And I think there needs to be some challenge there.
Thank you. Olive?
one thing is difficult, but I think it's really interesting to have this conversation in the context of the whole day and thinking about all of the conversations we've had about ethical regulation and behaviour and why that matters to this issue as well, that they are very much interrelated. So regulation and the development of proper regulation that focuses on EDI within the workplace as well is actually really valuable. There has to be teeth to discriminating against your fellow colleagues, and it's very much related to the question about our clients and lawyers. We are all part of the same community, so the discrimination that our clients face is often the same discrimination that a lot of lawyers face as well. Well, in some ways, and we can all make sure that we recognise we are part of the same community. But yeah, the regulators need teeth to deal with it.
Thank you very much. Can you give me your 2 favourite actions that people have said?
Yes,
They could
absolutely.
be random, they don't need to be favourites.
Yeah. One of them is try and convince the higher-ups of the value in terms of innovation and competitiveness. Continuing advocating for genuine social mobility. And create dedicated time for EDI initiatives, not in addition to the day job.
Fab. I think that brings us 1 minute over our time, and I don't want to annoy Gavin any more than I have done in the prep for this. So I think what I'm taking away from this is we were the best looking panel of the day. I think I've taken that away. I think that's a yes. And no offence, Stephen. And in relation to D&I, it seems to be about naming it. It seems to be about more regulation, more teeth. It seems to be holding people accountable, some training, getting the straight white guys, the poshos involved a little bit, and everybody doing something. So thank you so much. It'd be really embarrassing, by the way, if you don't clap. Thank you so much for the end of that panel. Thank you.
Thank you very much to the panel. Clearly, as you say, there is more to do, but the good news is there does seem to be some clear ideas on what it is we need to do. So hopefully everyone takes on board that action speaks louder than words. We need to do these things and all the other things that we've seen today. That does bring us to the end. And I want to thank you very much for coming today. I want to give you one last word from me to remember there is this wallboard outside, the action board. Please do go to it. I know you're going to run past it, but it's quite important that you do put your thoughts on there, because we're going to look at it afterwards and use it as our platform for action. And that leaves me now just to welcome back to the stage the interim chair, Catherine Brown.
Brilliant. Thank you. Thank you very much indeed. I've managed to avoid being remiked, so I hope you can hear me using this. This is good. Good. Thank you very much. So, yes, we're coming to the end of what I found to be a very energising and stimulating day, and I'm impressed with all of you who stuck with us right to the end, and I hope that means that you have found it similarly rewarding. I want to start by saying thank you so much to our outstanding panellists and speakers, the last panel, but all of the panels today, who I think really have provided us with some very valuable insights and different perspectives. Dean and Tanya, thank you very much for your exemplary hosting responsibilities, and the way you've taken those forward has really helped us in guiding us through some quite complicated discussions with real skill. So thank you both very much for that. I think we've, all the way through the day, we've talked about focusing on solutions, and thank you very much to everybody for engaging with that. I actually think there has been progress on the ideas board, so I can see some good ideas and thoughts on solutions emerging there, and indeed on the online discussions. But also, it's really obvious, in terms of the breaks, but obviously a really important part of days like today is the opportunity to network and talk to people. And I've heard some really stimulating exchanges in the margins of this conference, and I know that we'll all be reflecting on those and what we can take from those and how we can build on those relationships to deliver more change going forward. I mean, there are so many things, but a couple of the things that have really struck me have been the emphasis on collaboration. And, you know, that first panel that we had where we were really hearing about how delivering change in terms of access to justice requires collaboration, local collaboration, cross-sectoral collaboration, and national collaboration. So that I thought was really powerful. And a couple of provocations through the course of the day about, you know, can the regulators learn more from each other? I think that's that kind of collaboration. I think that was a really useful stimulus for us to think about. But also a lot of emphasis on challenge and how we challenge each other and ourselves. And, you know, I've written under my challenge, you know, I think Dan was pretty challenging in some of the approaches that he recommended, appropriately challenging. Same with Lloyd Hatton, Natasha Chatunde, Professor Debbie Foster. Those are correct and appropriate challenges to the status quo and to how all of our organisations do our work. And I hope, you know, I'm sure we will all be reflecting on what those challenges mean to us personally. And then just the last couple of ideas that I think I'm going to take away and think about from a kind of policy reflection point of view. I'm really interested in this idea about trauma-informed practice and the relationship between trauma-informed practice in the law and accountability and learning, and how you create an environment where there is accountability, but there is also the possibility of learning. And I think that that's not something I personally have had the opportunity to think about before, and it's something that I will be thinking about significantly going forward. And the other kind of intervention that made me really think, oh, there's something there I really want to follow up, was that thing around making public interest far more clear and comprehensible. So it's easy for us to say, oh, you know, yes, and of course, you know, the public interest, and yeah, what actually do we specifically mean? Because unless we can move beyond the kind of glib phrases, then we don't enable people to engage and challenge their own behaviour, or indeed collaborate with others to deliver change. So I found that very stimulating. So thank you again. We will really carefully think about every suggestion and every thought that has been shared with us today. Some things we'll take forward ourselves, others we'll work with partners on. I think it is worth, you know, it's worth reminding ourselves that we do, our pattern from these events absolutely is that we do take things away and do things off the back of them. So for those who were here last year, we had a great discussion on professional ethics, and it has very directly informed the consultation that we have launched today. And I've been really pleased that a few people have said to me, oh, I had conversations and I can really see how it's fed in. So, you know, that's absolutely, this is not a conversation that happens in isolation. This informs everything that we do through the year. You know, our work on EDI, similarly, as Craig has outlined, has been very much informed. And as we go forward in the work that we're doing on that over the next year, you will be able to see the inputs from today and from our discussions informing our work. So I just want, you know, I want you to know we really appreciate people putting in a good chunk of time and energy, and I want you to know that it's not wasted. It makes a difference. But of course, don't wait for us to act. Of course, you know, the connections that I hope you've been able to make and the ideas that you've been able to pick up today are valuable in themselves, and I really hope you'll be able to find ways to build on those within your own organisations or across the networks that you've made today. Every year we talk about the challenges, and clearly every year there are new challenges, and some of them feel sometimes quite overwhelming. But I think it is clear that we are together, we are making progress, and we're building our collective capability to address the challenges that we all face. And today's conversations and commitments represent another important step forward in our collective efforts to reshape legal services, and we all know how important it is that we do that. So please keep us in the loop with anything that you do coming out of discussions today. We'd love to hear about that. You'll be able to see what we do. And so then I think it just comes for me to say thank you so much to all of you again, but also to everyone who's made today possible, our technical team, the venue staff, our event organisers, and just everybody involved. So have very safe journeys home, and thank you very much indeed. Thank you.
you.